Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Welcome to our Curious Amalgam. I'm Alicia Downey. Before we begin today's episodes, I have a special announcement. Our Curious Amalgam has just passed 200,000 downloads. Thank you to all of our listeners. Everybody, tell a friend. Help us get to 300,000 downloads in record time. The title of today's episode is Leveling the Playing Field, the European Union's new regulation on foreign subsidies distorting the internal market. Government subsidies granted by individual EU member states are tightly restricted by state aid controls designed to prevent EU members from providing unfair competitive advantages to firms of their choosing. The problem arises when some competitors in the EU market enjoy the benefit of subsidies granted by non-EU countries who are not subject to state aid controls. In May 2021, the European Commission proposed a regulation on foreign subsidies distorting the EU internal market with the objective of leveling the playing field. A little more than a year later, on June 30th, 2022, the EU announced a provisional agreement on the text of this controversial and important piece of legislation. The new law will empower the Commission to investigate the financial contributions granted by the public authorities of non-EU countries to firms engaging in any economic activity within the EU. We'll be talking today about what this change means for the future of competition in the European Union. My co-host today is Matthew Hall. Hi, Matthew.
Hi, Alicia. It's great to be back.
Matthew, would you like to introduce our guest?
I certainly will. And just to give a brief quote before I do so, you said this is a controversial and important piece of legislation. And indeed it is. And when that agreement was reached in June 22, Bruno Le Maire, the French Minister for the Economy, commented, "The agreement reached on this new instrument will make it possible to combat unfair competition from countries that grant massive subsidies to their industry. This is a major step towards protecting our, i.e. the EU's, economic interests." So we'll discuss that today with Andreas Reindl. Hello, Andreas.
Hello, Matthew. Hello, Alicia.
Thank you very much for coming on. Now, Andreas is a partner at the competition team at Bael Bellis, the well-known competition law and international trade firm in Brussels and in London. Andreas, have you always been at VBB or have you been elsewhere in the past?
I relatively recently joined Bael Bellis, so it's about 6 years now. And before that, practiced antitrust law in Brussels and Washington with a large US-based firm. I worked at the OECD for several years in the competition division and then also held academic positions in the US and in Europe. So it's a not very linear career that in the end led me to VBB.
Okay, well that's interesting. Not linear is probably a good thing. You know, you give a variety of perspectives. So not always a private practice lawyer. It sounds like. So that is interesting. Well, thank you very much for that introduction. Well, Alicia brought us up to date. We're looking at a piece of legislation which was agreed provisionally in June 22. Likely to become applicable from around mid-2023. Could you just give us a bit more detail on what the European Commission, which originally proposed this piece of legislation, sees as the real rationale and how it will protect the EU internal market?
Sure. Alicia already mentioned, right? It's sort of the the basic idea of extending state aid control to foreign subsidies in short. But I think it's important to to see the regulation in the context of a number of other instruments that the EU either has adopted or that have been proposed, and they all based on a very similar rationale. So the idea is that the EU has very ambitious policy goals, imposes strict standards on players in the EU, and in various areas is now trying to find out whether there are instruments, approaches to impose similar or the same standards to players from outside the EU that are active in the European economy. So just to mention one or two, right? So you have a new regulation in the pipeline on carbon adjustment, border adjustment mechanism that would require companies to report carbon emissions for certain products. You have an initiative on deforestation-free products, and the idea is always how can we impose similar standards on foreign players that are active in the EU, and the same applies here for the foreign subsidies regulation. Alicia already mentioned, right? The EU has for a long time had very strict state aid rules, and the basic approach is that state aid is prohibited unless authorized by the European Commission. And if unlawful state aid has occurred, it has to be repaid. That doesn't mean that state aid isn't paid or doesn't exist in the EU. On the contrary, in recent years, there seems to be an increasing willingness to throw money at pretty much any market in the name of industrial policy. But still, it is a tight regime and it's tightly controlled. So the idea behind the regulation is, can we develop a mechanism that applies similar standards when third countries grant subsidies to companies in their countries?
As you say, there are rules already, and I think it's fair to say it's designed to be coherent with these other rules. If you think of the state aid rules, it's designed to kind of apply in parallel in a kind of consistent way with those rules, isn't it? If you read the regulation, a lot of it's very familiar to particularly state aid and other competition lawyers.
Yes, absolutely. I mean, the fundamental difference is I already mentioned state aid in principle is prohibited and always subject to an ex ante control. Here, of course, the foreign subsidy is not as such prohibited, but would be subject to an ex post control to check whether it has any effects on activities in Europe. So that's, of course, a fundamental difference that also then creates perhaps different administrative burdens. But that's in principle one of the basic ideas that are behind the regulation. The second one, of course, is important also. The EU already has an anti-subsidy control regime among its trade law instruments, which at the moment applies only to products that are imported into the EU. So to some extent, the regulation, one can say, is also based on existing anti-subsidies rules, but extend them significantly from imported products to any kind of activity within Europe. And you see also in the regulation, right, that if you look at the enforcement mechanism, that it's to some extent also inspired by existing trade laws.
Absolutely. As you say, those trade laws often apply just at the border. And here we're looking at things which are applying into impacts within the EU itself. Before we look at the basic principles applying here, at a high level, how important do you think this will be in terms of risks and administrative burden. I mean, I read somewhere that the Commission was intending to allocate some 150 FTEs to the implementation of this regime, which seems like a huge amount of manpower, suggesting a lot of cases. Do you think it's going to have a really significant impact?
Look, I think in practice, much will depend on how sensibly the Commission is willing to apply the new instrument. Especially at the beginning, will it focus on a few clear-cut cases to establish precedent, to develop guidance also for the market, and sort of start the enforcement more in a gradual way until it really has enough experience, or will it apply from the outset its leave no stone unturned approach that we see also in merger control. But be that as it may, it will have a very significant impact, right? We will speak later about some of the details or the elements in the regulation, but it could potentially affect any kind of M&A activity in Europe. It will lead to additional administrative requirements in transactions, in public tenders. It could lead to prohibitions of transactions on grounds that are not related to merger control. It could force players to share R&D on friend terms. So it will it will just also set in motion a very wide compliance mechanism to make sure that you don't see any delays in transactions in public tenders, so you're prepared for whatever is coming in the notification. So yes, it will. It has absolutely the potential to impact a wide range of players in Europe. Yes.
I think we'll get on to I think for a private practice lawyer, and indeed for in-house within companies, that compliance point you made is very significant, I think, and we'll get on to that. But let's look at the building blocks here of how the regulation is going to work. As we've said in the title, is this concept of foreign subsidies. It's all about foreign subsidies being granted to companies of any nature, EU and non-EU. So what is a foreign subsidy? We've mentioned that it's pretty similar to what we've seen in the EU state aid regime, but there are a lot of little difficult points there particularly for non-EU lawyers to understand. So can you just take us through what a foreign subsidy is in broad terms?
Right, and perhaps let me preface this with a little bit of good news, in a sense that it's always the European Commission that will enforce the new instrument. So initially there were some ideas, maybe member state authorities should also have a role, which would have made things even more complicated. At least we know now that the basic elements that we'll chat about in a second, they will be interpreted and applied only by one enforcer, that's the European Commission, although potentially within the Commission by different parts, which then may also at some point raise questions of consistency. But in principle, it's better than it looked at the beginning. So very quickly, the main points there is the question: do you have a foreign subsidy? And then, if that's the case, is the subsidy likely to distort competition? And if that's the case, the Commission still has to do some sort of balancing between potentially harmful and potentially beneficial effects. So this is the rough overview. Let me just quickly explain all three terms, what they really mean. Foreign subsidy is a term that again comprises several elements, right? So the first question is, do you have a financial contribution from a third country? And you already also said, right, we rely here heavily on state aid law, but we can also rely on foreign subsidies, trade law precedent to understand what is meant by financial contribution. And we will quickly understand this can be a lot, right? It can be, of course, a direct grant, but it can also be just a guarantee for repayments of credits. It can be a capital injection. It can be selective tax advantages. Many listeners will be familiar with the big case against Apple that the Commission, so Apple Ireland, that the Commission brought, which was just about particular tax arrangements. It can be purchasing products at a favorable price. It can be granting a concession without adequate remuneration. So we have behind this notion of financial contribution, a very, very wide concept that we are familiar to some extent from state aid law. But of course, players that haven't been active in Europe or haven't been the recipient of state aid for many companies internationally, this is a new concept. So that's the first one, financial contribution by a third country. And that's either a federal government, a provincial government, a municipality, so anyone that has public authority. But the regulation also makes clear that it can be a private player that makes a decision to make a financial contribution, loan, grant to a company where the decision is attributable to the government. So in certain countries, the government may be able to lean on a bank to provide a favorable loan. That would potentially be a subsidy. It has to benefit the recipient, so it has to be something that's not aligned with market principles or arm's length principles, and it has to be selective. So general tax cut for the entire economy would not qualify. A particular tax arrangement for one company or a few companies would. So that's the foreign subsidy. The second point, we already said it's a distortion of competition. And there it's important. So somehow improving the competitive position of the recipient. And there at least we have some guidance, right? Both from state aid law, but also from the regulation itself. It already says not all subsidies are created equally. So certain things like bailing out an ailing firm, export subsidies that are not aligned with the OECD instrument, money that's directly paid to be used in an acquisition or in a tender, they are presumed to be distorting competition. For others, we can assume that they are less likely to create an issue, be considered to be distorting, funding R&D or funding a project that's clearly localized. So we have some idea what is meant by distorting competition, but again, it's a case-by-case assessment.
So we've discussed the foreign subsidy and then the basic requirement that when this is being analyzed, there's a distortion of competition from that subsidy. So is that the end of this story, Andreas, or does the Commission have to, when it's looking at these things, think of anything else?
It's not. There is a third step involved, and that's the requirement to do a balancing test of EU interests. So how much is the harm? Are there any benefits? Benefits both for the EU that this player is active in the market, but also, and that's quite interesting, in this cost benefit analysis, which is inherently very vague, it's recognized that also benefits in the third country could be relevant to the extent they pursue policies that are also aligned with EU policy. So, for example, a subsidy that supports sustainability goals in the third country, that would be taken into account in the balancing test as a positive factor. So you can see it's not exactly precise science, but that's the third step that the Commission then would have to take before deciding whether there's a need to intervene.
I think it's definitely the case. It's not an exact science, is it? It sounds like there's a lot of scope for some litigation here. At the end of that analysis, and we'll look at when the Commission is actually going to undertake this analysis, what happens? Is it a so what? Do they issue a press release saying that this looks like a bad thing, or do they have some pretty significant remedies they can take here?
Well, like emergers, you hope they issue a press release and they say there's nothing to be worried about, right? But if not, if the Commission decides that there is a concern, yes, then it has substantial powers to intervene and require remedies or commitment types of remedies, right? It can that can range from repaying the subsidy that causes problems. It can be prohibiting a transaction or requiring parties to unwind a transaction. It can be the requirement to reduce capacity, something we know a lot from state aid law also. It can be granting friend access to R&D results or even production capacity. It can be the exclusion from a public tender. So it's quite strong remedies that can be at the end of the process if the Commission finds that a subsidy does cause concerns.
All right, so those are the building blocks, Andreas. It's not every transaction or every procurement situation which is going to be reviewed by the Commission, is it? I think we need to understand that there are only particular mergers and procurements that are going to be looked at. Probably of most interest to the audience are the mergers. So, against the background of those building blocks, what mergers are there, or acquisitions or JVs, is the Commission going to be looking at, and when do these transactions need to be notified?
Right. So the regulation does provide for notification thresholds, and that's that the target or a joint venture in Europe has revenues in Europe about of more than 500 million euros. And then there have been subsidies of more than 50 million over the past 3 years. But then to all parties, so including actually the acquired business. Now, just to also 2 words of caution. These are notification thresholds and not jurisdictional thresholds. So the Commission has the power also to call in any other merger where it has information that there may be subsidies that raise concerns. But the notification obligation is subject to the thresholds that we just discussed.
So that means it seems that companies need to be aware of the financial contributions that they've received, but also that the target has received in any of these transactions. What does that mean in practice? Should companies be collecting this information now, and what kind of things do they need to be looking at in that regard?
Sure. I mean, it will be, of course, mostly if you start from there, the acquirer, right? And it's important that the rules for transactions under the regulation are modeled closely after the EU merger regulation. And that applies also to the concept of who actually the acquiring party is, because there's a very wide notion of undertaking, which includes everyone that the acquisition vehicle controls, but also everyone that exercises control over the company that's actually participating in the transaction, plus all subsidiaries of the acquiring company. So that means for a global operator, in principle, subsidies that can be by third countries can be relevant anywhere in the world where the acquirer has business activities. So that's for one. Calculating the subsidies is like calculating revenues for purpose of the UMR, and you get really into a very complicated calculation if you think of a large global player, or for example a private equity group that has interest in many different businesses. So that's the first thing. And what
Just
follows
on
from
that,
that?
Andreas, I mean, anyone who's done these worldwide merger control analysis, it can be very difficult, but companies usually have a fairly good idea of where their turnover is derived.
I think that's a very good point.
Trying to
I
work
think
out where your subsidies are coming from or your financial contributions seems like it's really, where does this string end? It sounds like it can be anything.
that's an excellent point, Matthew. And I think to highlight what you said, right? Companies, yes, usually have revenue information readily available in the course of ordinary business. That's always gathered. Whatever else you gather in just in the ordinary course of business, right? But this regulation introduces a new type of information that needs to be gathered, which is not necessarily currently gathered in an ordinary course of business, right? So, in terms of practical steps, that would mean it's for any player that's, say, presumably active in the coming years in the M&A market, thinks that there are targets that it might be interested in. Any player that regularly participates in public tenders in Europe, I think it's advisable to start with some practical steps, and that the first one is what we just discussed, right? Just mapping out at least where are we active, where have we do we have connections with the government that result in transfers that could be considered financial contributions. But even things like who is actually collecting the information, who is reporting it, who is gathering it, which team is in charge of informing everyone what type of information is required, and then collecting information, so we have at least a structure ready to actually gather all the data input that we need if we are engaged in a transaction. I think that's a first step that is probably something that should be done relatively quickly.
Well, that's useful, Andreas. There's clearly a lot of steps which companies should be thinking about now. If they're caught by one of these, by the merger filing obligation, very briefly, what does that mean in terms of timeline? And is this something which applies separately from merger control and your FDI rules, or is this just yet another parallel regime that they need to be worried about amongst everything else?
Yes, that's a very good question, because it is important to consider that this is a third type of review, separate from merger review, separate from potential foreign direct investment reviews by member states, that has a different policy goal, that requires a different set of information, and then is subject to an independent review, which may be on its own timeline, which might not be necessarily coordinated with the other reviews. So that's why I said before, right? If you want to avoid delays, it's important to get ahead of the game, at least by mapping out how you gather information. If you know that you will eventually be involved in transactions, then it's time already to start gathering information, right? So what are the subsidies that we received? If there are red flags, potentially problematic ones, how do we argue that they are not harming competition? What arguments do we have for the balancing test? So that's something that can be prepared in advance. On the notification itself, I think our experiences will be exactly like under the merger reg, right? So the review periods are very tight, 25 days phase one, 90 days plus phase two, but we know that this exists only in paper, right? It can take you months to actually get a notification in, and presumably we'll have something very similar in foreign subsidy notifications. So doing homework now, getting prepared, I think really has a premium.
And does that apply equally, just briefly, in the public procurement area as well? We mentioned that briefly, but there's a similar type of notification regime there, isn't there?
Right. It's a similar notification regime with slightly different thresholds. And a slightly different mechanism, because procurement is usually before member state authorities and not before EU authorities. But in principle, the idea is the same. If you are above the threshold, you have to notify subsidies, or at least declare that you didn't receive any. And that would then be passed on to the Commission, and the European Commission again would be in charge of investigating in phase 1, potentially phase 2, whether there is a concern about a distortion of competition, and during that period, in principle, so the firm under investigation cannot be awarded the contract, but there might even be the risk in particular circumstances that a firm that is not under review could even be awarded the contract before the Commission has concluded its review. So there's a similar mechanism, but of course in the procurement process, it works a little different. But let me just make one final point also, and that's because we talked about so much about the burden and the concerns and the risks, and they're real. But I think if you are a player in Europe, you can see this also as an opportunity, right? So, for example, if you purchase European assets and you are a buyer that's already done the homework, or that can already say I'm clean, or I know what it is, and I know that this should not create concerns, you may be better off than rival potential buyers who are behind the curve. And the same, of course, in procurement. There may be many American players that actually benefit from the fact that competing bidders from countries that pay a lot of subsidies may have a problem to comply in time with all the requirements. So I think it's important to look at this not just as an instrument that will create burdens, but if you are engaged in an economic activity in Europe, and you feel also that there is an issue that some of your competitors benefit from third country subsidies, I think this is also a tool that can well be used as an opportunity to compete more successfully.
Well, that's some excellent advice. I know I learned a lot during this conversation, and I think I can think of immediate implications for U.S. companies doing potentially looking at acquiring European assets. But what we'd like to do now is turn to the final segment of our program and do with you what we do with every guest, which is to ask you to tell us something interesting about yourself that's outside of your professional life.
So I'm not certifying that it's very interesting, but outside my professional life, from the time when I actually studied law, I was a semi-professional, or at least very dedicated singer. I studied classical music at the Conservatory in Vienna, continued then afterwards to sing for a while. It hasn't been my principal activity aside from law in the last couple of years, but I continue from time to time to perform in church, to perform. I've recorded was participating in the recording of a CD. So that's my non-legal life.
Oh, wow. So what's your voice? Tenor, baritone?
I'm a baritone, and have particular interest in Baroque music and then contemporary music.
Oh, that's wonderful. Heading now into the home stretch, we're going to play a little game with you that we call the Curious Hat.
And now it's time for the Curious Hat!
Okay, the surprise question for you, Andreas, is this. Play your cell phone ringtone and tell us why you chose it.
All right.
Okay.
Let's
Get
listen.
it queued up. Yep. Go. Okay,
So
very beautiful piece of music. What's the story?
this is from Bach's Cello Suite Number 1, and the story is that I see the cello as my second hobby and tried to play it for a while, and this is how far I got to play a little bit of Bach, and it's just wonderful music.
It is. Another secret about you has been revealed. Thank you so much. And thank you very much for being a great guest today. We learned a lot. And we will be looking with great interest at developments after the regulation goes into effect. So thank you for speaking with us.
Thanks, Alicia, and thanks, Matthew, for having me. It was great fun.
And for those of you listening, join us for our Curious Amalgam next week.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.